Hello and welcome to KPMG's webcast on the changes introduced in relation to bearer instruments by the Companies Act 2014. My name is Francis Hackett and I'm the chairman of KPMG Legal Services, and the webcast will also be presented today by Michael Moore, who's an associate director with KPMG Legal Services. In this webcast, Michael will be responding to some of the key questions we have received in relation to bearer instruments and the changes introduced under the new Act. We will first be asking Michael the meaning of the term bearer instruments as it's defined in the Companies Act. Next, we will ask Michael to explain the changes introduced in relation to bearer shares under the new legislation. Thirdly, Michael will explain the legal status of bearer instruments issued by Irish companies prior to the commencement of the new legislation. Finally, we will share with you our recommendations as to what steps or actions companies and instrument holders should take in the light of these recent changes. So to begin, Michael, maybe you might start by taking us through the definition of bearer instruments as it's set out in the new Companies Act.
Thanks, Francis. In essence, a bearer instrument is a document which entitles the holder of the document to title or ownership of the shares in the company described in the instrument, even though the holder of the instrument is not recorded in the register of members of the company as the holder of those shares in the company. The bearer instrument also entitles the holder of the instrument to transfer the title or ownership in those shares by simply physically handling or delivering the instrument to another party. Bearer instruments are sometimes referred to as share warrants, and the shares to which they relate are known as bearer shares. Actual physical possession of the bearer instrument is key. Title or ownership in the underlying bearer shares can be transferred by simple physical delivery of the instrument without the need to document or evidence in writing the transfer of ownership. The holder of a validly issued bearer instrument was, prior to the commencement of the new Companies Act, entitled to present the bearer instrument to the company, whereupon the company was required to actually issue the underlying bearer shares to the holder and record their shareholding in the register of members of the company in the usual way.
Thanks, Michael. So the key takeaway for anyone listening to this webcast is that, as the name would suggest, a bearer instrument is a document which entitles the holder of that document to prove his or her title or ownership to the shares in the company by means of the simple fact of holding possession of that bearer instrument. No registration is required to prove ownership, simple possession suffices. So Michael, maybe you could take us through the key changes that have been made in relation to bearer instruments under the new Companies Act.
The Companies Act 2014 took effect on the 1st of June 2015 and has repealed and replaced all existing Irish company legislation. Section 66, subsection 9 of the Act provides that since the 1st of June 2015, private companies no longer have the power to issue bearer instruments. Section 66, subsection 10 provides that if a private company purports to issue a bearer instrument, the bearer shares that are described in the instrument shall be deemed not to have been issued, and the amount paid by the party attempting to subscribe for those shares shall be due as a debt owed by the company to the purported subscriber. Section 1019, subsection 3 of the Act provides that since the 1st of June 2015, public limited companies also no longer have the power to issue bearer instruments, save for what are known as permissible letters of allotment. Permissible letters of allotment are letters of allotment issued by a PLC to its existing shareholders in respect of either a bonus issue of shares, shares issued in lieu of a dividend, or shares issued in connection with a rights issue.
What is the thinking behind these changes?
This prohibition on the issue of bearer instruments by Irish incorporated companies was introduced by the Oireachtas for a number of reasons. The measure seeks to improve transparency by ensuring that in the near future, the legal owners of all shares in Irish incorporated companies will be apparent from the register of members of the company. It is hoped that the change will help to enhance Ireland's reputation as a place to do business and frustrate efforts to use shareholdings in Irish incorporated companies for money laundering purposes.
So Michael, let's consider again in more detail the key provision of the Companies Act, section 1091, in relation to the transition period in respect of bearer shares issued by PLCs and what they should do in relation to bearer shares they have currently issued and what happens if they do nothing.
Section 119 subsection 7 applies an 18-month transition period which runs from the 1st of June 2015 until the 30th of November 2016 in relation to bearer instruments already issued by PLCs. The PLC shall during the transition period procure the entry in its register of members of the name of the holder of shares by way of bearer instrument. If the PLC fails to do so before the 1st of December 2016, the PLC shall then be required to register the Minister for Finance as the registered holder of these shares. Section 1019, subsection 8, introduced a further restriction in relation to the right to transfer shares under a bearer instrument. This right to transfer shall cease 21 days prior to the expiry of the transition period. This means that on or after the 9th of November 2016, being 21 days before the expiration of the period, it will no longer be possible to transfer shares under a bearer instrument.
Thanks, Michael. So the position in relation to PLCs is fairly clear. What's the position in relation to private companies that may have issued bearer shares before the 1st of June 2015?
Unfortunately, the position in relation to private companies is less clear. The new Act is silent in relation to the legal status of bearer instruments issued by private companies before the 1st of June 2015. The legal permissibility of the issue of bearer instruments or share warrants by private companies prior to the 1st of June 2015 is open to question. The concept of bearer instruments or share warrants challenges the essential restriction that exists on the membership of or the transfer of shares in a private company. If a bearer instrument was purportedly issued by a private company prior to the 1st of June 2015, inquiries should be made and the articles of association of the company reviewed in order to establish that the company had the power to issue bearer instruments. This is a matter on which specific legal advice should be obtained in a given case. The Companies Act 2014 provides no similar transition period for the conversion by private companies of bearer instruments to issued shares as to the transition period we've seen in respect of PLCs.
Clearly, this webcast deals in a general way with the changes introduced by the Companies Act in respect of bearer shares. It is not, of course, a substitute for legal advice which would be required in relation to each specific instance and which we would be happy to deal with you on if you have any further queries. Please contact either myself or Michael, and you can of course connect with us on LinkedIn if you would like to stay in touch. For more information on the Companies Act and what it means for your business, please see the links attached and our publications on the right-hand side of this web page. Thanks very much for listening. We hope you found this webcast useful, and we look forward to speaking with you soon in relation to other company law issues.